This is Barry Zalma on insurance for YouTube. I am an attorney who has retired from the practice of law and now spends my time as an insurance claims consultant, insurance expert witness, author, and creator of these YouTube videos. Today I'd like to talk about the law of unintended consequences and the tort of bad faith. Now, the law of unintended consequences is not statutory. No state or federal government has enacted it into law. No executive has signed the law. It is rather a law of the nature of people. It is an adage or idiomatic warning that an intervention in a complex system always creates unanticipated and often undesirable outcomes. Science and general observation allow the statement that actions of people, especially of governments, will always have effects that are unanticipated or unintended. Economists and other social scientists have heeded its power for centuries. Regardless, for just as long, politicians, insurers, and popular opinion have largely ignored it to their detriment. It is a law that must be obeyed and is almost always obeyed whether one wants it to be obeyed or not. Insurance is a necessity. Neither the courts nor the governmental agencies who deal with insurance seem to be aware that in a modern capitalistic society, insurance is an absolute necessity for doing business. No prudent person would take the risk of starting a business, buying a home, or driving a car without insurance. The risk of losing everything would be too great. By using insurance to spread the risk of loss, taking the risk to start a business, buy a home, or drive a car becomes possible. Insurance has existed since a group of Sumerian farmers more than 5,000 years ago scratched an agreement on a clay tablet that if one of their number lost his crop to storms, the others would pay part of their earnings to the one damaged. Over the eons, insurance has become more sophisticated, but the deal is essentially the same. An insurer, whether an individual or a corporate entity, takes contributions, premiums, from many and holds the money to pay those few who lose their property from some calamity like a fire. The agreement, a written contract to pay indemnity to another in a case a certain problem, calamity, or damage occurs by accident, is called insurance. Consider some examples of unintended consequences and insurance. Simplified wording was required by statute to make it easier for people to understand their insurance contracts, which before had been written by lawyers and basically were only understood by lawyers and judges. Insurance contracts can be simple or exceedingly complex, depending on the risks taken on by the insurer. Regardless, insurance is neither more nor less than a contract whose terms are agreed to by the parties to the contract. Over the last few centuries, almost every word and phrase used in an insurance contract have been interpreted and applied by one court or another. Ambiguities in contract language seem to disappear. However, the average person saw the insurance contract as incomprehensible and impossible to understand. Courts struggling to understand policies of insurance added to the concern of legislatures. And as said in Insurance Company of North America versus Electronic Purification Company, a 1967 California Supreme Court case, the insurance company gave the insured coverage in relatively simple language easily understood by the common man in the marketplace, but attempted to take away a portion of this same coverage in paragraphs and language which even a lawyer, be he from Philadelphia or Bungay, would find difficult to understand. Ostensibly, to protect the public, to salve the concerns of jurists like the one quoted above, insurance regulators and legislatures decided to require that insurers write their policies in easy-to-read language. Because they were required to do so by law, the insurers changed the words in their contract into language that people with a fourth-grade education could understand. Precise language, interpreted by hundreds of years of court decisions, was disposed of and replaced with imprecise, easy-to-read language. The law of unintended consequences, of course, as always, came into play. Instead of protecting the consumer, the imprecise language resulted in thousands of lawsuits determined to impose penalties on insurers for attempting to enforce ambiguous, easy-to-read language. The lawsuits cost insurers and their insureds millions, if not billions of dollars to get court opinions that interpret the language and reword their easy-to-read policies to comply with the court decisions. For more than 30 years, the unintended consequences of a law designed to avoid litigation has done exactly the opposite. The attempts by the regulators and courts to control insurers and protect consumers were made with the best of intentions. The judges and regulators found it necessary to protect the innocent against what they perceived to be the rich and powerful insurers. Unfortunately, the plain English statutes had the opposite effect. But of course, the fact that easy-to-read policies cause more problems than they cure, the law and regulations have not been changed because it feels good to compel insurers to continue to write easy-to-read policies which give lawyers and insureds the right, therefore, to sue insurers to make them pay for risks of loss they never assumed. Consider that in the 1950s, the California Supreme Court created a tort new to United States jurisprudence, the tort of bad faith. A tort is a civil wrong from which one person can receive damages from another for multiple injuries. The tort of bad faith was created because an insurer failed to treat an insured fairly, and the court felt that the traditional contract damages were insufficient to properly compensate the insured. The court allowed the insured to receive, in addition to contract damages that the insured was entitled to receive under the contract, had the insurer treated the insured fairly, also damages for emotional distress and punitive damages to punish the insurer for its wrongful acts. Insureds, lawyers for insureds, regulators, and courts across the United States cheered the action of the California Supreme Court for providing a fair remedy to abused insureds. Most of the states across the United States adopted the tort either by judicial fiat or by state statute. after the creation of the tort of bad faith, if an insurer and insured disagreed on the application of the policy to the factual situation, damages were no longer limited to contract damages as in other commercial relationships. Because, of course, an insurance contract is nothing more than a contract. And every other contract cannot result in a tort if the contracting parties act in bad faith. Only an insurance contract becomes a tort if a party can prove the other acted in bad faith. If the court found that the insurer was wrong in denying a claim, it could require the insurer to pay the contract amount and additional damages for emotional distress, pain, suffering, inconvenience, punishment damages, attorney's fees, and other damages the insured and the court could conceive in order to deter other insurers from treating their insureds badly. The courts and the legislatures, adopting the tort of bad faith, hoped that the tort of bad faith would have a salutary effect on the insurance industry and force insurers to treat their insureds fairly. However, claims for a $40 claim wrongfully denied resulted in a $5 million verdict. Juries unaware of the reason for or operation of insurance decided that insurers that did not pay claims were evil and that they wrote contracts so that they never had to pay. The jurors were convinced it was appropriate to punish insurers severely, even when the insurer's conduct was correct and proper under the terms of the contract, because by so doing, other insureds would get claims paid, whether they were owed or not. The massive judgments were publicized, and many insurers decided fighting their insureds in court was too expensive, regardless of how correct their position was on the contract. They found it less expensive to pay than to fight, just as shop owners threatened by the mafia decided it was better to pay protection to the mob rather than fight. Most of the massive verdicts were reversed or reduced on appeal. The bad actors raised their premium and lost little business. Other insurers, faced with the massive verdicts, allowed fear to control reason and paid claims that were improper or fraudulent. The extra cost was passed on to all insurance consumers. The insurers who acted improperly were punished less than the honest insurers who were threatened with punitive damages for conduct that was not wrongful. The insurers who treated their insureds badly, in fact, profited, since they continued their wrongful acts and only were required to pay the few insureds that sued. Those that did not sue added to the wrongdoers' profit margins. Honest insurers paid frauds and claims they did not owe and found they needed to raise premium charges to cover the extra expense. The increased premium paid by insureds to cover the extra expense were a clear example of the effect of the law of unintended consequences. The law of unintended consequences struck the insurance industry and the insurance buying public. Rather than deter wrongful actions, the law of unintended consequences resulted in punishing the honest and correct insurers, honoring the insurers who acted in bad faith with profit they were not entitled to earn, and allowed many insurance frauds to succeed. State insurance departments, near the turn of the 21st century, recognized that insurance fraud is a serious crime, taking multiple billions of dollars from the insurance agent industry. Local police and prosecutors were not concerned, even after insurance fraud was made a felony, because no one suffered physical injury or death. Insurance fraud just cost a lot of money to insurers who were perceived as extremely wealthy and more victimizers. Since almost no one was being prosecuted for insurance fraud, states like California enacted statutes that required insurers to thoroughly investigate all claims, institute a special fraud investigation unit whose only purpose was to detect, investigate, gather evidence, and present the evidence to prosecutors to prosecute the crime. The special investigation units, the SIUs, did the work, only to find most of their investigations were ignored, and their successes received little or no encouragement from the insurers or the state. Both wanted all claims settled quickly and fairly. The salespeople could not explain why the fraud perpetrator clients were being placed under oath and asked to prove their loss rather than just receive a quick and unquestioned check. State law made all insurers doing business in the state as the only entities required by law to investigate and help the prosecution of criminals seeking to defraud the insurer. All other persons and entities, whether they are the victim of a crime, reported to a police agency who investigates the crime. Reporting a crime like a robbery to police has no consequence to the person reporting the crime, nor does that person have any obligation past reporting the crime, since they are immune from suit for doing the public service of reporting a crime. Because insurers are compelled to investigate their customers, who the insurer believes have committed a fraudulent act, if they err, then they are charged with breach of the covenant of good faith and fair dealing. The suits for erroneously, even in good faith, reporting an insured to the state for fraud exposes the insurer to tort damages and punitive and exemplary damages, and therefore the state compels them to investigate fraud and report it to the state fraud units, only to put the insurer in a position of being sued for doing so. The privilege provided to protect those who report suspected crimes to police agencies is often ignored or sidestepped by the courts, as the California Supreme Court did in a case called Framathalito versus Fire Insurance Exchange. In that case, the insurer who denied a claim for fraud and saw its insured arrested and tried for insurance fraud was made a defendant when the insured was acquitted, and it was sued for bad faith. And the California Supreme Court said the insurer had to defend itself from the tort of bad faith because they did not determine the reasons why Framathalito was not convicted, although a criminal case requires evidence beyond a reasonable doubt, while the civil case only requires a preponderance of evidence. What is needed, in my opinion, is to do away with the tort of bad faith and allow only recovery of contract damages. If an insurer acts in bad faith, each state insurance department has the power and ability to punish that insurer and compel it to act in good faith. Giving insureds the opportunity to profit from a claim will only instigate more claims, more bad faith among insurers and insureds, and make it impossible to properly prepare for and charge premiums for an insurance policy. This video was adopted from my book on unintended consequences, and The Tort of Bad Faith, which is available from Amazon.com as both a Kindle book and a paperback. You can also find information about the book from my website, www.zalma.com, and click on the link to the insurance claims library.